Right out of the gate, the judge makes something crystal clear. Losing parenting time is serious, but not every dispute automatically qualifies as a legal emergency. That's an important distinction in family court. Judges have to balance a parent's rights with a child's immediate safety, and the threshold for an emergency hearing is much higher than many people realize. But here's where things get interesting. The father's attorney isn't backing down. He's about to argue that going 25 days without seeing your child is itself an emergency. So who's got the stronger legal argument here? Let me know in the comments before we hear the evidence.
I don't see any emergency circumstances that would have necessarily justified an expedited hearing in the case. I really don't see that the allegations that he has alleged constitutes an emergency.
First off, respectfully, we would disagree that this is not an emergency situation. He has gone without parenting time for 25 days.
Versus Zach Rodriguez, respondent. It is case number 2019 DM 298. Petitioner apparently appears along with his attorney, Alexander Vasquez. Eric Kidwell appears as counsel for the petitioner in this case, the mother. Where is she located, Mr. Kidwell?
She's seated right behind me in this Zoom recorded hearing.
All right, I now see her. I also have named Haley Dunn on this meeting.
Haley Dunn, one of our exhibits was a witness statement from Miss Dunn, who was there when all of this occurred. So she's present in case the court has questions or if the court will allow me to ask her what happened.
All right, very well. It's the court's understanding that this was originally scheduled as hearing on an emergency motion that Mr. Rodriguez initiated on his own, noting, of course, he designated this to be in the District Court of Sedgwick County. I think this case is actually in Butler County, and his motion probably should have been rejected by the clerk's office for an improper caption, but nevertheless, it was accepted for filing. The court's aware of it. I've read the motion, and I could just make the initial statement is that I don't see any emergency circumstances that would have necessarily justified an expedited hearing in the case. While I don't make light of his loss of parenting time for any reason, I really don't see that the allegations that he has alleged constitutes an emergency. Rather, the court is of the belief that the mother's protection of the child very well, or her efforts to do so very well, may have constituted emergency circumstances. But obviously that it's not her motion that we have before the court. We are where we are. The matter comes before the court at this time. The court is generally aware of each party's position in the matter. Mr. Vasquez, I know you're apparently new to this case. You didn't file this motion. Your client did. What is your position on behalf of Mr. Rodriguez at this time? What needs to be done?
Well, Your Honor, first off, respectfully, we would disagree that this is not an emergency situation. He has gone without parenting time for 25 days, starting July 17th. He has joint residential custody, Your Honor, and I have prepared a presentation to address the facts that led us here today, if the court would allow.
You may.
Thank you, Your Honor. Your Honor, so there are certainly some serious allegations being discussed here today, and we don't intend to minimize any of them. But I think it's important from the outset to distinguish between two very different questions. The first is whether respondent took appropriate action when he learned that there had been inappropriate behavior occurring between the children in his household. He did. Second is whether those allegations gave petitioner the unilateral authority to suspend his parenting time, court-ordered parenting time, indefinitely. They did not. Your Honor, when respondent learned that the children had been, Your Honor, there was an incident here. It happened in October. He found out, he walked in, he saw them underneath the blanket. And he immediately panicked. He separated the children. At that point, they were sharing a bedroom. They had bunk beds. Your Honor, these are children. At the time, it was 4 years old and 6 years old. 5 years old. 5 years old and 7 years old. When he learned that happened, he immediately separated the children. That same day, I think An hour later, he went out and purchased separate beds so that the children would no longer be sleeping together. He made it a rule to where they can't be together unsupervised anymore. And they are essentially, he had a talk with each child. He didn't want to traumatize the minor child. Again, this was, to him at this point, this is the first time an isolated incident, first time it happens. These are children. Importantly, Your Honor, there's no allegation that the respondent himself engaged in any inappropriate behavior with the children, with the child. There's no allegation that he encouraged this behavior. The issue involving the children was identified. He intervened. He changed the sleeping arrangements to prevent it from happening again. Again, he took each child, discussed why that was inappropriate. He made rules. He made it a norm where they couldn't be together and by themselves. They weren't to be allowed unsupervised. They weren't allowed to be behind closed doors, but unsupervised in the same room. What happened in July is different. Petitioner learned about the prior incident and made the decision that she, not this court, not DCF, not law enforcement, not the PFA court, she would determine when dad would continue seeing his daughter. She started withholding the child July 17th. Again, she made all these reports. There's an active Roseville Police Department report. There's an active DCF report. She filed a PFA. She did everything except ask this court for relief. And all these organizations, all these investigations.
This is where the case becomes incredibly complicated. The father's attorney isn't denying that something inappropriate happened between the children. Instead, he's trying to convince the judge that his client acted responsibly the moment he found out. In custody cases, courts often look less at whether a problem occurred and more at how the parent responded afterward. Did they ignore it, or did they take reasonable steps to protect the children? That's exactly the question this judge will have to answer, and it could determine the outcome of the entire hearing.
Going on, no authority has determined that he is unfit to parent or that he acted inappropriately. So, despite utilizing all those available mechanisms, there's still no order suspending his parenting time, yet she continued to withhold the child. That's why we're here today. Again, Your Honor, I want to be careful about the terminology being used here. We are talking about two very young children. These are 5 and 7-year-old children. Their ages matter. Their ages matter when the court evaluates about the conduct and dad's response to it. We're not suggesting that inappropriate touching between children should be ignored. It shouldn't, and it wasn't. When dad learned about the inappropriate behavior, he took it seriously. But there's a significant difference in acknowledging inappropriate behavior between two young children and immediately assigning adult concepts and adult motivation behind that behavior, Your Honor. So what did Zach do what did he do with that information? Dad intervened. He explained that it was inappropriate. He made sure the children would no longer share a room. Again, he established rules that these children should not be left together unsupervised. Those restrictions still remain active today. So I disagree fundamentally with petitioner's characterization that he failed to protect the minor child. He identified a problem. He identified a problem with two young children, implementing concrete safeguards designed to prevent it from happening again. Your Honor, there was an incident that happened in July. And again, we're here to be transparent. There was an incident that happened in July with the minor child of the parties here. It didn't involve his stepson, Cincinnati. It did involve another child while in petitioner's care. And Ms. Dunn is here today. She provided a statement, and I'm sure she could clarify what happened that day. But essentially, the minor child was in a similar situation with another little boy in petitioner's care. I mean, the facts are laid out in both the motion and the response. They interviewed Ms. Dunn apparently interviewed the child. She said, yes, my dad has gotten mad at me before for doing this. He talked to me. It happened. They called dad. Dad immediately said, yes, I absolutely. I thought it was an isolated incident. In retrospect, he should have made mom aware, But again, to his understanding, this was an isolated incident that happened once. It hadn't happened since. He took the safeguards needed to protect the children, and he acknowledges that he should have reached out to mom. He should have reached out. He should have made her aware. But hindsight is 2020. We're here now, and he's taking this very seriously. He immediately sat down with mom and her new husband. They talked about therapy. He said, absolutely, now this has happened again. She needs to be in therapy. We need to do whatever it takes to make sure, this doesn't happen again, to make sure that all children are safe. So the child's in therapy. Immediately, what happened here is that the blame became that this happened because of him, and she allowed it to happen. Your Honor, that's not what happened here. Again, these are children. When he saw it, he acted in what he believed was the appropriate measure. What happened after that was, again, mom, starting on July 22nd, unilaterally refused to withhold a minor child. But actually, she said, you can have visitation of a minor child, but I need to have your location on my husband's phone. We need to be able to track you. How that's relevant or synonymous to the situation that happened, I'm not sure. She started creating her own orders. She started creating her own restrictions. She contacted the Roseville Police Department. The police department
Now the legal battle shifts in a completely different direction. The father's attorney argues that the mother crossed a legal line by deciding on her own to stop court-ordered parenting time. Whether you agree with her decision emotionally or not, family courts generally expect parents to seek a judge's approval before changing custody arrangements unless there's an immediate, unavoidable danger. It's one of the biggest mistakes parents make during high-conflict custody disputes, and judges pay very close attention to it.
Called the police department. They investigated the police officers, and I believe that's our Exhibit F, Respondents Exhibit F, and it's page 29, the report by Officer Zachary Hobson. The officers told mom that they would not condone her violating a court order. They told her, this is not the appropriate remedy. You need to go to the court, ask for relief. We're not condoning you violating a court order. Yet she continued to withhold parenting time. She filed a PFA against the little boy. It got denied. She was asked, and in that PFA, which is in our exhibit D, is a petition for the PFA and the summons. She requested sole legal custody. She requested supervised visitation. Again, it was denied. She has continued to unilaterally deprive respondent of parenting time here.
I would object with the statement that it was denied. It's going to be heard, as you know,
the temporary order
this month.
She did not get.
And it was only denied because she named a child and didn't have an attorney and didn't know to name the parent involved. So it's not been denied. It's set for hearing.
Temporary orders was denied. Relief was denied. The only court orders enacted at this point in time are the one awarding dad to have joint residential custody, Your Honor. So, Your Honor, she was free to file an emergency motion with this court. She was free to file the PFA. She was free to file an investigation with DCF, which has been investigated to dad's knowledge. What she was not free to do was appoint herself as a judge. She could not simply decide, I believe there's a safety concern, therefore the existing parenting plan no longer applies. Your Honor, again, they submitted a video for this court to consider. We have watched the video, and he says in the video, he sits there apologetically and says, hey, I had no way of knowing it would happen again. I thought I handled it. I thought I put all the safeguards, and it hasn't happened again in his household. It happened again in petitioner's household. And granted, had he advised her, would she have not left the children unattended? Absolutely. But to his understanding, this has never happened before. It never happened before. He's always had joint residential custody for all of the child's life. He has never witnessed a similar incident with his child. He had no way of knowing that it would continue to happen. He had no way of knowing that this event would trickle down to the July event with Ms. Dunn's child. So in the video that was presented for evidence before this court, Dad was attempting to de-escalate. He said he took full accountability of the fact that he should have let mom know. It was a poor lack of judgment, and I think this court would agree. He immediately acknowledged the fact that the child needs to go to therapy. He acquiesced to whatever he needed to facilitate that, and he contacted law enforcement whenever she required parenting time, Your Honor. So here, Dad has tried to do everything to de-escalate and try to do everything to prevent this situation from happening again. Your Honor, this was a, for lack of a better word, a tragedy that happened and that happened again in July. He takes full responsibility for his poor lack of judgment of not contacting mom. But he used his judgment. He thought that he was acting within his, right as a parent. He pulled them to the side and he thought he handled the situation. And Your Honor, this demonstrates his willingness to act in the best interest of the minor child. Your Honor, we have submitted text messages and Respondent's Exhibit G of petitioner refusing parenting time. Almost every single day since July 22nd, he has reached out and said, "Hey, I need to see my daughter. She needs to see her father. What's going on? Why can't I see her?" She's been unilaterally refusing to exchange the minor child. She knows that the safeguards are in place where neither child is going to be left alone, and quite frankly, the child shouldn't be left alone with other children in either home. Pursuant to the accident that happened with Ms. Dunn's child, and that's not good enough for her, Your Honor. So really, we're asking for this court to reinstate his parenting time and to acknowledge the fact that it's in the child's best interest to have meaningful relationships with two parents. This has been a traumatic event with the child. She's now seeing a therapist. She's been yanked apart for the status quo of her having meaningful parenting time with each parent. Now she's in therapy. This has shifted her whole world. We strongly believe that it's in the child's best interest to have respondent's parenting time restored. Your Honor, if the court has any continuing concerns about interactions between the minor child and his stepchild while the investigation occurs, he is prepared to abide by reasonable safeguards, the same safeguards he has already implemented, that the court can order that the children remain separated. The court can require separate sleeping arrangements, which is already implemented. The court can prohibit unsupervised contact between the minor child and the other minor child, which again is something already implemented. But none of those measures require depriving the minor child from time with her dad. There's less restrictive solutions available, and respondent has demonstrated his willingness to implement it. Your Honor, so to wrap up, respondent is not asking this court to ignore what happened. He's asking the court to look at what he did when he learned about it. These are two young children, 5'7". He acted.
Notice the strategy here. The attorney isn't claiming his client handled everything perfectly. In fact, he's openly admitting mistakes, especially failing to tell the mother sooner. Sometimes acknowledging an error actually makes a witness appear more credible because it shows accountability instead of denial. The question now becomes whether that mistake was serious enough to justify cutting off all parenting time. That's the legal line this court is about to draw.
About separate beds, pose rules, told the child separately, talk to them. Could he have communicated with Haley sooner? Absolutely, he should have. But a failure to communicate is not a failure to protect, and it does not make him a danger to his daughter. Petitioner had concerns. She had every right to report them. She contacted law enforcement, ECF, pursued a PFA. But reporting a concern does not give her the unilateral right to rewrite a court order. And I think that's the fundamental disconnect here, Your Honor. The alleged conduct involved another child, but her solution was to remove father from her daughter's life. Corporate safeguards are justified. Unilateral suspension of father's parenting time is not. And until this court changes its order, the order is not optional, Your Honor. We ask this court to enforce it. Thank you. Nothing further.
Mr. Vasquez, you mentioned earlier as part of one of the options for the court, separating these two children. What did you mean by that?
Separating no unsupervised contact, Your Honor. Separating them. They're already separated in different rooms. There has already been a rule since the October incident that they're not to be unsupervised. That is what respondent meant separate, to continue the separation that's already implemented. But if this court has any other alternatives, Your Honor, he will follow them. He hasn't seen his child since July 17th, I'm sorry. He's willing to abide by any court orders that the court issues here today.
Very well, Mr. Vasquez. At this time, the court will turn to Mr. Kidwell. Your client's position today, Mr. Kidwell?
My client's position, based on facts that were not disclosed during that presentation, is that he should have supervised parenting time. And I want to explain that this is not the first incident. And I want to explain Mr. Vasquez was talking about the text messages. I'm going to ask the court to go to Bait Stamp page 23, which was part of the text exchange. And this is between, obviously, my client Haley and Zach. And on Bait Stamp page 23, Mr. Vasquez was correct. He keeps asking every day to see the child. My client responds, quote, "Zach, you have known about this for approximately 10 months. I only learned about it 2 weeks ago because you didn't inform me despite me being Ember's mother. I have serious concerns for Ember's safety. You took action when Cincinnati was reportedly touched by his mother's cousin's son, and they no longer have any contact. Why is Ember's safety concerns being treated differently?" So the reality is that this behavior has occurred numerous times in Dad's home, and he never reported it because he didn't want to get any.
Misstatement of facts. That's not correct.
My witness, Miss Dunn, will testify as to every bit of the entire conversations. We also submitted the videos of Zach admitting that this had occurred previously.
And it
had occurred. Yes, they're included in our exhibits. So obviously there's an issue, and it's a trust issue. You know, he was married to his wife, Gabby, in January of this year, and I don't know what the disconnect is here. If something like this happens, especially if kids are just experimenting, that's, the parents get involved and that's what happens. But when these things have happened before, but you don't know anything about it until the 17th, that's a huge, huge problem. And yes, as a matter of fact, my client said we need to get the child into a therapist. That's on Bait Stamp 12, Exhibit 4, that Ember has been receiving services at South Central Mental Health on July 24th. She's participating in outpatient mental health and community-based services to address ongoing emotional and behavioral concerns. She has a diagnosis of F9 1.8, other specified disruptive, impulse control, and conduct disorder, she demonstrates functional impairments in multiple areas, including functioning within the home, behaviors towards others, mood regulation, and self-harmful behaviors. So, however long this has been going on, that should have been communicated. And I'm not talking in October of last year. It was happening before then with other kids. And then she finds out.
Your Honor, again, we would object. That's not true. Anything that petitioner knows has been disclosed by respondent himself. That's simply misleading to the court. And we have to object that that's not true. They've only been together for a year and a half. The incidents that happened with another child were prior to him even knowing the child. Therefore,
This closing argument ties everything together. The father's side is asking the judge to focus not on perfection, but on effort, arguing that he acted, accepted responsibility, implemented safety measures, and wants to continue being an active parent. Now it's the court's turn to weigh parental rights against child safety, one of the toughest decisions any family judge has to make. What do you think the judge should do after hearing these arguments? Share your thoughts below, and if you enjoy real courtroom breakdowns with legal analysis, don't forget to like, subscribe, and turn on notifications for more.